Hello and welcome to the Study Legal English podcast. My name's Louise, I'm your host, and today I'm really pleased to be joined by a special guest. It's Barrie J. Roberts. Hi, Barrie J. Roberts, how are you?
I'm fine, Louise. Thank you so much for having me.
Thank you. So for those of you who are tuning in and you're like, who is Barrie J. Roberts? Well, Barrie J. Roberts is the author of the Getting to Yes Guide for ESL students and professionals, Principled Negotiation for Non-Native Speakers of English, which is a fantastic book, a one of a kind, which is out at the beginning of April 2024. And so we're talking all about this, negotiation and Barrie's book. So that's the topic of this podcast. You're in for a real treat. So Barrie, to begin with, I thought it would be nice just to get a little bit of your background. So what's your background and context?
Well, I started off as a lawyer, a public interest lawyer in California. And then I became a bit disheartened with the law and became an ESL instructor. I'm leaving a lot out. And after I became an ESL instructor for a while, I missed the law, but I didn't want to go back to practicing the same way. And I became very interested in mediation. And as it turns out, as an attorney, I settled almost every case with great results for my clients. Although I had planned to be a trial lawyer, it never really worked out because, if I may say so myself, I was better at settling than at litigation. So I picked up on this theme while I was teaching a grammar point in an ESL class and thought, what am I doing? I need to do more. So I began taking mediation courses and found it quite interesting. But as a new ESL instructor and as a new mediator, I found so much similarity between the two fields. And I received permission to try teaching mediation as an ESL topic and to use mediation and negotiation role plays in my ESL courses. And this really took off. My students loved it. My colleagues loved it. And so I just began experimenting and teaching this way. So I have taught at University of California, Berkeley, and at the Chapman University School of Law to LLM students, lawyers, business professionals, even engineering students who thought they had no interest in negotiation and mediation. They were just interested in a new, exciting way to learn English. So I have combined all of these bits and pieces from my background in order to write this book.
Fantastic. Brilliant. Yeah, it's funny how, I think a lot of ESL teachers and also legal English teachers have similar sort of patchwork stories of coming from the law and then falling into ESL teaching and then trying to bring in your legal skills and how you can make a difference. And so, yeah, that's nice that you found a way to implement your skills into your teaching, which, a lot of the listeners will agree. Of course, negotiation is incredibly important. Mediation is really important. And then learning the language of English and the skills involved for that are also essential. So you mentioned the book. So the Getting to Yes Guide for ESL students and professionals, Principled Negotiation for Non-Native Speakers of English. What's the book about? We've got a long title there, but we've got some key words, the Getting to Yes Guide. Some listeners might be familiar with that phrase. So what's it about?
My book is a guide to the classic negotiation book called Getting to Yes by the Harvard Project on Negotiation. So that book is about a type of negotiation called principled negotiation, which your listeners may be quite familiar with. It can be summarized in two words, actually one word said twice, which is win. Win-win negotiation. I think most people are familiar with that phrase. Would you agree? That's true in the US. I don't know if it's true.
Yes. Yeah. Win-win, I think, is used quite a lot in Europe and probably, I think a lot of English learners who I've spoken to have heard of this term. But if you don't know what it is, listeners, win-win. Hopefully it's self-explanatory, but you're looking for an outcome in negotiation where both parties win. That's what I would say. What would you say, Barrie?
Oh, exactly. That's exactly it. So instead of thinking of negotiation as a competition or as combat with a winner and a loser, the idea is we're looking for ways for all parties to win and to leave on good terms, to actually improve the relationship in the process. So the authors begin by setting out something they call the standard methods of negotiation, which most people think they have to choose between, which is number one, hard negotiation, which is one person wins and the other person loses, and the winner doesn't care one bit about the relationship between them. And the other is the opposite, soft, where both sides give up, give in, don't get their needs met. However, they think that this is a way to protect the relationship. So the authors talk about a third way, which is neither hard nor soft. And by the way, not medium either. We're not looking for a compromise. It's a completely new way to approach the dispute or the conflict, which is to look underneath what everybody seems to think they want, to look underneath the positions to find out what is really needed, what will truly satisfy all sides.
Yeah, it's a really sort of helpful way of looking at negotiations, especially if long-term business relationships are needed in a deal. And for the listeners, if you haven't heard of the book, I'm sure many of you have heard of the book Getting to Yes, because it's a landmark book in negotiation. If you haven't heard of it and you do negotiation, then I would recommend that you go out and buy it and read it. But this is where Barrie's book comes in, because you might read it and, well, think that you know what it means, or maybe you don't and you get confused with it. And in any case, you know, you need to be able to understand it and to understand the language. And actually, Barrie's book is a guide to understanding it. Is that right, Barrie?
Well, that's exactly right. And I made the mistake the first semester I tried to use it with my LLM students, because for me and for any native speaker of English, the book is delightful, easy, charming. It's written for lay people. It's not written for law and business students in legalese or businessese. That's a word I can just make up. It's written for the popular audience. And the authors are very clear that they want it to be an all-purpose negotiation strategy to use with family, to use with friends. So to me, that's how it was. I was very new to teaching English as a second language at that point. So I just told my students, read this book. We will use it as a basis for negotiation and for mediation. Well, what I got back from the students was a lot of suffering rather than the pleasure I thought they would receive. They took many, many hours to read it and either thought they understood it and didn't, or didn't understand it. It was not a happy situation. So I started to read the book from their point of view. And even in the first few pages, I could see most of the words were unclear to them. They seemed like basic English words, like the word standard or the word merits, the word settle for. All of these words seem so obvious to me. I didn't think it would give them any problem, but I was wrong. They needed a lot of help. So for that semester, I had to teach the book in mini lectures. And then for the next semester, work on exercises to guide the students through it. And this became the basis for the book. So what my students taught me how to teach it to them. And that this book is really from my students to the world.
Fantastic. That's great. Yeah. I think it's nice when a book emerges from your own teaching practice, because you're addressing a need, really. And clearly you've got the experience through the teaching to be able to provide something that's highly relevant, hopefully, to other learners. And you mentioned a few words there that come up that could have different meanings throughout the Getting to Yes book, like settle, for example. So, are there words that are important for negotiation that have these different meanings and that you explain in the book? Should we talk a little bit about that?
But all four can simply be a fact. We settled for $1 million. It doesn't tell you if they're happy about it, if they're not happy about it. It's just the fact we settled for this. But settled for can also have a negative connotation, a grave disappointment. We settled for $1 million. You have to hear the nuance, because it could mean we were expecting 10 million, but we had to settle for 1 million. Likewise, the word standard. It's a standard word. It's used in a very standard way. However, in getting to yes, the standard methods of negotiation, which I talked about before, hard or soft, this is a negative use of the word standard. But in another chapter, maybe the next chapter, standard methods of listening or standard methods of active listening, this means they are tried and true. They're standard because they have been shown to be useful and effective. So what does the word standard mean? In the book, when the word could be used in several different ways on the same page, which was very confusing to my students. They thought they had the definition. They plugged in the definition. It didn't work every single time. Sometimes it does, sometimes it doesn't. So this is why I created my book as a universe of terms that only apply to the specific context of getting to yes. So you can look up a word in my glossary and look at the page number and apply it to that meaning in that specific context. It may not work outside of this universe.
So settle for, yes, settle for is a really important word. And of course, so listeners pay attention. It could mean different things in different contexts. It could be positive, it could be negative, as could, some of these other words, standard, Barrie mentioned, could have a different meaning depending on the context. Are there any other words that caused confusion? Of course, there's loads, but any key ones?
Well, one surprising word that caused confusion was the word to, T-O, in one of the chapter titles and one of the key concepts for negotiators, BATNA, best alternative to a negotiated agreement. So that first semester, when I just gave the book to my students to read, their understanding of this term was that, of course, you are making counter proposals during a negotiation, and you're trying to create the best counter proposal that you possibly can. That's what they thought it meant. I don't know what they did with TO, but I tried to explain to them that a BATNA is not what you do during a negotiation. It is what you do before a negotiation to plan for what you will do if you're getting a very disappointing proposal from your opponent or your counterpart. So what it means is you think about what you will do if you cannot get a reasonable settlement agreement with your counterpart. How can I walk away from this negotiation and have the best result possible? It's the best alternative if I cannot reach an acceptable agreement with the other side, not the best proposal I can make in response to my counterpart's proposal. So I've had to explain this till I was blue in the face many times, because my students were sure they understood the process of negotiation and using counter proposals during a negotiation. So there was something about the word to that threw them off.
Yeah, it's funny how, prepositions, they're very challenging. They're so challenging. They're these small words, to or from, before, after, these prepositions, which in any language, I think they're probably one of the most difficult things to learn, because the rules in your own language do not apply when you're then learning this other language. And sometimes they don't make sense. And we've got some weird usage of prepositions in legal English. I think an important point for listeners is that we say an alternative to something, and an alternative to something means you've got one option and the alternative to that option is something else. And so, as Barrie mentioned, your best alternative to a negotiated agreement is something that is not the negotiated agreement. It's an alternative something else that you do instead of the agreement, but which is still, as Barrie mentioned, still really good, hopefully. Do you ever give examples of like BATNA? Because I usually, when I try to explain it to my students, I usually talk in terms of if you're dealing with, for example, a breach of contract and you're trying to negotiate a settlement. So you're trying to negotiate some kind of agreement. One party pays damages to the other party or some kind of compensation outside of court. You're trying to negotiate a settlement outside of court. If you don't reach an agreement, an alternative to that agreement would be to go to court, which I don't think is good in any situation. However, the party who has been injured might consider that to be their BATNA, their best alternative to a negotiated agreement. If they can't reach what they want in the negotiation, then what's the alternative? The alternative would be going to court. Of course, is it better than the negotiated agreement? Well, maybe it depends on a number of factors. Would that be a good example, do you think, Barrie? Would you use that example? Have you got any other examples of explaining BATNA?
Yes, I do. And I want to say your example is exactly what we call a reality check in the terms of when we do a cost benefit analysis. Maybe the agreement starts to look a little better when you start comparing it to going to trial. So it's a very useful exercise. But the power of the BATNA is walking into a negotiation knowing that you have an alternative to accepting your bottom line or something worse than your bottom line, or the worst possible agreement you could accept might be better than your BATNA, or your BATNA might be better. So one example I use is imagine going into a job interview where you know you have two other possible jobs lined up in case this interview doesn't go well, versus going into a job interview desperate and having no other options. So if you can just feel that in your bones, you get the power of a BATNA. You can just imagine how your body language would shift, how your tone would shift, how your confidence, your power. Who has the power in that interview? The interviewer, the interviewer, both. So this is why the BATNA is such a powerful tool for negotiators. It can save you from making a very bad deal, because, of course, a bad deal can be worse than no deal.
Yes, a really important concept. And I don't know whether to call it a technique, or would that be right? It's like, define your BATNA before the negotiation so that you can use the power of BATNA, as you mentioned.
It's a tool in your toolbox.
A tool. That's the right word. A tool. That was the word that I was looking for. Good. Okay. So let's move on and let's have a look at some exercises that students could do, or some tips that you have that listeners could do.
Yes. In my book, I have 10 tips. The tips are for readers of Getting to Yes who need and want to confirm their understanding of the book, or who need help in the first place. So I have 10 tips for using my guide to Getting to Yes. So this will only be interesting to you if you plan to read Getting to Yes.
All of the listeners are saying, yes, I'm going to go and buy Getting to Yes, and then I'm going to go and buy Barrie's book so that I can read it. Yes.
Well, I hope you will, because my idea for the guide is for readers to have their own legal English instructor by their side as they read Getting to Yes, to help you when you know you need help and when you're not sure whether you do or do not. Anyway, you can open up my guide and find out. So there are several ways to use the guide. And one is to just start reading Getting to Yes on your own. And if you get stuck, you can look up a word in my glossary. As I said before, the glossary matches Getting to Yes. It's not just a generic dictionary where you have to figure out how to define the word for the particular sentence you're reading. There's a match. In fact, I hope that for the online version, the words will have a hover, the hover function where you can just click on the word and the definition that you need for that particular sentence comes right up. I'm not sure about it because this won't be available till April 8th or 9th, but that was what I requested. So that's one option. Just start reading Getting to Yes and refer to my guide as needed. Another option, it's not particularly about my guide, is to get the book Getting to Yes in audio version so you can hear it and feel it, get the spirit of the book and hear the pronunciation and the intonation. And you can do many things with that. You can listen, you can repeat, listen to yourself recorded and compare your recording to the audiobook recording. There are many things you could do with it. There are also videos, not about Getting to Yes itself, but about the concept of principled negotiation. One of the authors, William Ury, has his own website with videos that he has made. And I find this very useful to give a foundation, a background, so that when you read the book, you're walking into a universe you're already quite comfortable with. If you've heard it, if you've seen him give lectures, you feel like you're in the family.
I didn't know William Ury had his own site with videos. I've never come across them. So as soon as we finish this interview, I'll go and have a look at those videos. That sounds like a great resource.
Well, I hope you will. They're wonderful to listen to. They're very accessible. By the way, his site also has links to translated versions of Getting to Yes. I hesitate to mention it because the whole point of my book is that if you're planning to negotiate in English, you should be thinking in English and reading it in English. But his website is well worth exploring.
Fantastic. Yeah, I'll have a look. And yeah, I think you're absolutely right. Listeners, don't go and buy and read it in your own language. Read it in English because it makes much more sense. If you are going to be negotiating in English, dive straight into the English and then use a guide like Barrie's guide to guide you through that language. It might be more challenging, but it will be more fulfilling and helpful to you in the long run, I expect. Okay, any other tips?
Well, the other tip is that if you use my guide, I have many opportunities for you to check your understanding and apply your understanding to your own needs for negotiation. So I have questions for you to consider before you read and after you read. And I actually wrote a little short story for every chapter that uses the concepts and vocabulary in terms of art in new ways. We call it recycling the language and the vocabulary. And I hope the stories are entertaining and maybe a bit more updated than some of the author's examples. You know, that's another reason I had to write the guide is because the authors use many stories and anecdotes that are delightful for me, but left my students with very blank stares. Some of them are very old. Some of them are easy for people in the US to understand, but not elsewhere. So I tried to explain the author's examples and anecdotes and then write some that might be more modern and user-friendly for an international global audience.
Yeah, you've done a great job. And I really like the glossary is really fantastic. And I think it's such a unique book. I mean, I've never seen anything like it before. And I see just how much work has gone into it. And because it's so valuable and so targeted, it's well written and it's easy for somebody who is reading the Getting to Yes, they can go and directly find these meanings. And, you know, I think you mentioned that the meanings within the book, they can have different meanings. And so you're exactly explaining the exact meaning, where it exactly is in the book. A lot of people might be thinking, oh, I could just go on ChatGPT and ask them what this word means nowadays, or go on Google, but you're not going to get the same tailored response because you might get something that actually confuses you more. When you're learning a language, you want to find the resources that actually help you and don't confuse you more. And this guide is certainly one of those which will help you in your understanding of this book. Any other tips?
I can give one quick tip, and that is to read Getting to Yes and my guide with a skeptical but open mind. So I am not trying to say that everyone should read and use this approach, and that's the end of it. Your troubles are over. No, I am inviting you to understand getting to yes and principled negotiation for your consideration. Millions of lawyers and business professionals, judges, diplomats, customer service agents, government officials have been trained in this method. It may or may not be the right method for you, but whether it is or isn't, it's very helpful to understand where your opponents may be coming from. And you may pick up a few new tools to add to your tricks. And, the authors have a whole section on doubt and skepticism about the method, and they're ready for your challenges. And you can read questions that other people have raised about the method, read their responses, and make your own decision. The point of this is not to push this particular method on anyone, but to understand it.
Yeah. We would hope that if you're a lawyer, hopefully you have the ability of critical thinking. So go in there, as Barrie mentions, with an open but skeptical mind, challenge, think about, reason yourself whether you agree with the methods or not, but go in there and read it, because Getting to Yes is like a foundation book that all negotiators should read, and as like a fundamental basis to go from, and then develop your negotiation skills and also your language. And to do it in combination with Barrie's book would be helpful, because you'll understand it more fully. And then if you agree with it or not, no problem. But you've at least educated yourself on one of the fundamental negotiation texts. So good. All right. Thank you. I think that's really, really helpful. We have covered quite a lot. Have you got any final thoughts?
Well, one hope that I have for my guide is to create a global community of people who are using Getting to Yes as a lingua franca for negotiation, and using English as the lingua franca to use that lingua franca of principled negotiation. And someday, perhaps I'll have a Facebook page or some other way for us all to connect with each other, and we can discuss our experiences applying Getting to Yes, or help each other with suggestions for using it, talk about our successes, our failures, our goals for applying principled negotiation to many different situations.
Sounds like a good aspiration for listeners out there. If you've read Getting to Yes and you were confused by it, and you've got questions for Barrie, or you read it and you agreed with it, or you're thinking of reading it, or you're a teacher who's interested in alternative dispute resolution, you can certainly email Barrie. Barrie, can we say your email?
Yes, of course. bj.roberts@yahoo.com.
Okay, I will also post it in the show notes for sure. So don't worry, listeners, if you were scrambling, if you were urgently trying to find a pen there, or trying to rewind and write it down, don't worry, I will post it in the show notes. So do get in touch with Barrie. I'm sure she's pleased to hear from you. And also, I noticed that, I know this is probably opening up a can of worms. I don't know if that's the right expression, opening up a whole new topic, but you're also writing another book, right?
Yes, I am. The second book is a very comprehensive approach to alternative dispute resolution. It includes negotiation, and not only principled negotiation, but good old-fashioned competitive negotiation, as well as principled negotiation, as well as mediation, and the field of alternative dispute resolution as practiced in the United States.
It's still aimed at English language learners?
Yes, it's aimed at lawyers and business professionals who need to understand how alternative dispute resolution works in the United States, but it also has the tools for using negotiation and mediation anywhere in English. I'm working right now on the teaching guide to that book. And so there's going to be a textbook that readers can use on their own for self-study or in a classroom. There's also a teaching guide, and there will also be online companion materials such as checklists. For example, how to plan a competitive negotiation, a checklist, and then many explanations in what I hope is accessible English. So the ideas are complicated, but the English can be plain, simple, and accessible. That is my goal. And the idea is the book mirrors an alternative dispute resolution course in the United States that a law student or a business student might take, but tailored for non-native speakers of English. So it's not only about the English, it's also about cultural differences, legal culture, business culture, and to raise awareness about some of the differences in our legal and business cultures and how to manage with someone from the US.
I need a copy of that book. It sounds brilliant. I've done some teaching with mediators and there's barely any resources in this field. So that sounds like a fantastic book. So listeners, to sum up, you've heard all about Barrie J. Roberts' book, The Getting to Yes Guide for ESL Students and Professionals, Principled Negotiation for Non-Native Speakers of English. I'll post the title, of course, in the show notes so that you've got that and so that you can go and look out for it when it comes out. And then you can also keep an eye out for Barrie's next book, which will be on ADR sort of more generally, as she described there, but still aimed at you, basically, still aimed at lawyers, business people who are learning English and who use ADR in reality and you use English in real life. So thank you very much, Barrie. That's fantastic. It's been really, really lovely to hear about your book, to hear about your work. So thank you for coming on the show.
Thank you, Louise. It was a pleasure talking with you. And I know you understand this inside out. So I really appreciate it.
Thank you. Thank you. And good. So listeners, thank you for listening and see you next time.